Hi, this is Devin at Westchester Residential Opportunities, and this video is part of our series on the basics of fair housing laws. The normal caveats and disclaimers apply. This presentation is being prepared in May of 2020 and may not be accurate on any other date. We are also not providing legal advice in this video. If you need legal advice, please engage a lawyer. Today we're talking about reasonable accommodations and modifications, a crucial element of disability rights in housing. Reasonable accommodations and modifications can often be the determining factor in one's access to and enjoyment of their home. So let's get into it. First, we'll be tackling reasonable accommodations. Reasonable accommodations may be revisions or exceptions to the rules and policies of a housing provider so that a tenant may have full enjoyment of a dwelling. This can also include adjustments to a municipality's policies under Section 504. For example, zoning requirements may need to be adjusted to allow for the development of housing for people with disabilities. Let's go over some examples to make this a little easier to understand. Reasonable accommodations can take the form of many different types of policy adjustments. However, there are some requests that WRO sees frequently. Firstly, therapy dogs. A common form of emotional support animal, therapy dogs are often requested by the tenant for psychological and emotional reasons. With the help of a reasonable accommodation request, an owner can negotiate a building's pet policies, fees, or restrictions. Parking spaces. An assigned parking space may be necessary for those with mobility disabilities. By making the proper request, tenants may receive a safe and close spot, regardless of a building's parking policy. And lastly, unit transfers. Possibly due to the result of a mobility or physical change, unit transfers occur when an individual's unit is no longer the most accessible option for them. Through a reasonable accommodation, the tenant may be able to accelerate and simplify the transfer. Now, on to reasonable modifications. Reasonable modifications are physical changes to the dwelling or building that are necessary for the resident to fully enjoy the premises. They can include structural changes to interiors and exteriors of dwellings and to common public use areas, and must be allowed at the tenant's expense. Housing providers may require the unit to be restored to its pre-modification state. On the next slide, we'll look through some common modification requests from WRO's clients. In contrast to reasonable accommodations, reasonable modifications speak to physical changes in one's private unit or common space. They frequently involve making a property more navigable to individuals with wheelchairs or mobility disabilities. Requests may include ramps. Ramps may need to be constructed to and from one's unit, within one's unit, or in common spaces. Handrails. Locations are similar to ramps. It is considered reasonable for them to be added to the route to one's unit, within one's unit, or in the common spaces, in most cases. Grab bars. Most frequently installed around bathroom appliances, grab bars are frequently crucial to creating an accessible living environment. Now, let's look at some common questions and misunderstandings in the world of reasonable accommodations and modifications. So, what constitutes a reasonable accommodation or modification request? Well, there is no blanket definition. A reasonable request often must be reached through landlord and tenant negotiations. Some useful benchmarks may be to examine its financial and administrative burden, the harm it could cause to other tenants, its technical feasibility, and its reversibility. While the answer to these questions may differ depending on the situation, in general, requests should fall towards no for the above questions. Now, we'll look at who can make these reasonable requests. Reasonable accommodation and modification requests can be made by any individual with a disability. A person is considered disabled if they have a physical or mental impairment which substantially limits one or more of their major life activities. This can include mobility, developmental, psychiatric, and emotional disabilities, among many other categories. For example, people with AIDS, recovering alcoholics and drug users, and those perceived to have disabilities are all protected. If you're unsure whether or not you have a disability, consider this. Does your condition impact your ability to complete mundane tasks? If so, you may be entitled to protections. There are two ways you can go about asking for a reasonable accommodation or modification. First, place your request orally. While possibly more convenient, this method may be a higher risk. The lack of paper trail may make it harder to prove that you made the request if your housing provider fails to respond in a timely manner. Second, in writing. Through email or trackable mail, this method is a better option in keeping your housing provider accountable. This method may also be inevitable, as medical documentation can be requested by your housing provider. That is, unless your disability is apparent. So, who picks up the tab? Well, it depends on the location of the modification. In private housing, the tenant or resident may be required to pay for the cost of a modification to their personal space. They may also be asked by the housing provider to keep funds in escrow to restore the unit to its original condition. In common areas in the state of New York, the housing provider is financially responsible for the cost of modifications. And in government-subsidized housing, the provider pays for the modification if it's readily available, within reason, and does not pose an undue administrative and financial burden. It should be noted, independent of the type of housing, private or public, a housing provider may not require a higher rent, an additional security deposit, or any other fee in response to the modification. The tenant must be treated equally before and after they submit a request. And there you have it, the basics of reasonable accommodation and modification requests. If you believe that you or someone you know could benefit from assistance with making a request, please reach out to WRO. Thanks again for watching our video. If you're aware of housing discrimination, please reach out to us to report it. We're creating this video during the COVID-19 pandemic, so we're not currently in the office. So the easiest way to reach us is by email. We have a staff directory on our website. You can see the address on the screen. Email anyone in the Fair Housing Department and we'll get right back to you. And while you're visiting that website, please take a moment to support WRO by clicking the donate button. Housing is always essential. We're here to help. Like, subscribe, and share this video. And please follow us on social media.